So Dwight, I guess, because judicial activism gets talked about a lot, and sometimes I wonder whether people just mean it in the sense of they don't agree with the laws that, or they liked the laws that ended up being struck down, or they don't agree with the judicial decision. So, is there kind of a way of defining judicial activism that you think is sort of, puts a kind of boundary on what exactly that means?
Well, I don't think it's simple, because I agree with the sense that sometimes that's the way people use it, is to describe decisions they agree with and decisions they don't agree with. However, I think we could distinguish between decisions where the court is operating within its role versus decisions where it may be expanding or overstepping its role. Or decisions where the court is operating within traditional conceptions of, for example, rights and freedoms, and those where it's adopting a novel interpretation of rights and freedoms that's less rooted in those traditions. And so I think we could have principled ways of distinguishing between activist decisions and non-activist decisions.
So, to take from your panel, you were talking sort of about recent decisions. Is there an example from those decisions where the court, in your mind, went beyond what it should have done, or not should have done, but beyond how it should have acted or should be acting?
I think there have been recent decisions where it has taken on more of a policymaker role than it had to do. And in some of those decisions, it's been overturning past precedents without even necessarily explaining as fully as one would hope why it's doing that. And in doing so, it's taking on some novel interpretations of certain rights. And obviously the law isn't static and may change over time, but when it takes on very novel interpretations of certain rights, there is room to say that it's engaged in some degree of activism.
What does that mean? Because I heard that come up, this idea that it went against precedent, which I guess to my, I'm not steeped in sort of legal ideas, but this idea that it went beyond precedent, why is that necessarily, or why could that be a bad thing? Because it seems to me that, the world changes, things change. Right. Why wouldn't the court change?
Right. The idea of precedent is that unless there's a strong set of reasons for changing, that you would stick with the decision that's been made, because otherwise people don't know what the law is. In order that they can follow the law, they're guided by the past decisions, and so the courts should be also, unless there becomes a strong reason to change. And when there is, courts may change precedents, but they should offer a very well-articulated reason why they're changing when they do that. And I'm not convinced that in every recent case they've articulated a sufficiently powerful set of reasons for changing precedent.
For the average, voter, citizen looking at this, beyond whether or not they agree or disagree with the decisions of the court, is this something they should be concerned about? And then, how should they view the way the court is acting and what it's doing? Should there be some way that they should imagine the court changing or the legislature changing to sort of set things to arrive at a better balance, I guess?
Well, one of the difficulties is that when the court makes a decision based on constitutional rights, it very much limits what legislators can do after that. These are often difficult questions where there's balancing of different things at stake. And when the court ends up making the decision, it may mean that there's no more opportunity to make a democratically chosen decision, to engage in democratic debate about the issue. If the court's decision applies for some period of time, there's a consequence now that debate is essentially shut down on the issue. And so I think citizens should be concerned about that, because on these big issues, citizens should be engaged in those issues, and people won't all agree over those issues, but we have a stronger democracy when people are engaged with those and argue about those and make decisions through democratic means where that can be done, rather than those decisions being made through the courts that don't engage in that same range of discussion.
In terms of, to use the most prominent case that we're getting right now, the assisted suicide decision, you had some you had some concerns with the way that ruling was written, but in terms of the idea of judicial activism and how the legislature should be working and how our democracy should be working, what is, I guess, do you have specific concerns about how this issue has played out?
Well, the court certainly has put Parliament in the position of having to do something and do something very fast. On an issue where Parliament has dealt with the issue before in voting down a number of bills. It doesn't say that Parliament shouldn't be considering the issue, but Parliament could continue to consider it in light of broader public discussions without the court saying that unless something is done in the next year, this declaration comes into force that strikes down the law in part.
If I understand the court's ruling, it comes on this idea of people suffering, and so how should Parliament, and how should the public then deal with that? Like, should Parliament be free to ignore that fact, or is the court right to step in and say no, what the current situation is unacceptable?
Well, certainly if there are people that are suffering constitutional harms or constitutionally recognized harms, there is a role for courts to step in those issues. But they could make different kinds of declarations than what they've done. And Parliament could want to respond in very different ways than what the court has effectively forced. So if Parliament responded with a really good palliative care strategy for Canada, right now it seems that wouldn't actually even allow it to proceed without still changing the law. And that's a response Parliament might want to pursue, but the court's decision no longer allows for that at the present time.
All right, thank you, sir.
Sure, thank you.